SJC-11496, Commonwealth versus Bonnett.
Good morning.
Good morning. May it please the court. I'm Jean Kempthorne. I'm representing the defendant, Darkins Bonnett. I'd like to focus, if I may, on the Roviero issue first and then proceed to the issue of counsel's failure to argue that the evidence failed to prove premeditation. Right before trial in this case, Bonnett filed a motion for discovery after a late disclosure of a joint task force contact with a confidential source.
How do you know it was a joint task force? I don't see that really developed in the record.
It's in the record, Your Honor, that it is a, just looking at the form itself, which is attached to my motion and to the defendant's motion. It's on an FBI FD 1023 form, and it indicates both an FBI agent and some Lynn
Yes, I
police.
understand that they said that the Lynn police were taking part in this, but that doesn't make it a joint investigation
Correct.
necessarily.
That's correct.
And the judge denied relief in part because he thought it was not a joint investigation. He had been told, I don't remember where I saw this, that the federal government was paying for everything, and that they weren't even really acting as Lynn police while they weren't even on the Lynn police payroll while they were doing this. So I don't see anything here that suggests that it really was a joint enterprise here.
Well, I don't know how it would be anything other than a joint enterprise if there are Lynn police who are involved. But in any event, none of this was fleshed out in terms of real evidence. It was just kind of suppositional hearsay, attributes by Mr. Gubitosi, the prosecutor.
Did the defendant ask or object at any point to proceeding this way? I didn't see that he did. You want this discovery, you want it because you know of it, and you want to talk to the whoever it was that the FBI and the Lynn police spoke with, and the Judge Whitehead, as I recall,
Correct.
Says, well, why don't we just have you make some calls? And I'm not hearing the defendant saying, well, that's not good enough. You really need to have a hearing on this, Judge. You need to conduct some kind of an in-camera hearing. This is what the case law says. And it sort of acquiesces in everything and that Judge Whitehead does.
Well, he doesn't acquiesce at the key point, which is to say, when he says, well, Your Honor, I mean, this is material. And he files the motion, they have a sort of a hearing, and he says, he makes an argument for why it's material. Does he do a whole lot more? I mean, no, but that's par for the course for the way he handled the entire trial, was largely acquiescent. I felt it was enough that he had preserved the issue, that I argued it not as ineffective assistance, along with a lot of whole other grounds of ineffective assistance, but I considered this a preserved claim because the motion had been filed in writing. There was indeed a hearing, and he made some kind of an argument, and I thought that was sufficient. I do believe it is sufficient to raise the issue as a preserved issue. But on the merits of that issue, Judge Whitehead should have held a proper hearing. There should have been something other than hearsay to support the, and I agree with you, Justice Lank, it's very unclear whether, what task force was this? I mean, what was the connection to this offense? I mean, we have no evidence whatsoever that there was a compelling governmental need here to withhold the evidence.
How did the defendant find out about this?
Pardon?
How did the defendant find out about it?
The DA's office faxed to him the redacted report.
So that had been provided to the DA by the Lynn police or by the FBI or by whom?
Presumably the Lynn police, but I mean, a lot of this should have been fleshed out in a hearing, because it obviously got to the Commonwealth, so it was in their possession, and we don't know anything about that. Judge Whitehead was willing to just accept the most cursory, responses from the prosecutor. Well, I'm not exactly sure, Judge, but I think, I'm not even sure they're even on the Lynn payroll, et cetera, et cetera. There should have been a real hearing. There's, significant due process concerns here. Roviero, all sorts of cases say there has to be, the court has to make a very careful assessment of the defendant's interest and the government's interest. And if the government is adamant that the material should not be produced, then you have to dismiss the case. That's a choice the government's put to.
Well, only if the information seems to be really material to the defense. And there's some question here, it seems to me, about we don't even know anything about somebody said they'd heard something on the street. It's really attenuated stuff.
I don't believe it is attenuated because this is the way a defense is investigated. This is the way a defense is even framed, and you decide based on your investigation what are the viable theories. Your Honor, the threshold for materiality is actually very low, and once you've reached that threshold of materiality, then the court has to look at the governmental interest. And that is not done here. I mean, this is a witness who's in a position to testify. It says that right on the face of the report. I say that the materiality here is evident on the face of the document. It mentions my client. It mentions the victim. It mentions another person present. It's exactly about this. At the very least, you would want to know whether the witness would speak to the defense investigators, and from there you would see whether you could find a precipient witness or whether, in fact, the witness would testify and hearsay in his possession or her possession would be admissible on some theory. This is highly material. It goes directly to other culprit evidence. I mean, this isn't attenuated at all. Attenuated is Sinelli. Attenuated is Day. Anonymous tip files. Somebody watching the news and seeing, a composite and saying, gee, that looks like so-and-so, where you have the person watching it has no connection whatsoever to the event. That is not this case.
But, of course, he was in a position to testify pursuant to the memorandum, but if he had testified and said the word on the street is, it would never have come in.
Well, there's cases out there that say this could have been relevant even to a Bowdoin issue. I mean, if the defendant had had this material and had been able to pursue it, they could have at least admitted it with respect to whether or not the police had investigated this tip, had investigated this source. I mean, presumably this is a reliable source.
Now, I know you bristle at the suggestion that there should have been any kind of attempt to push this at a motion for new trial.
Yes.
There was a motion for new trial?
That I brought.
And that was based on ineffective assistance of counsel?
It was.
And in the course of deciding whether or not this was or was not ineffective assistance of counsel, wouldn't this have been a relevant area to examine, that had counsel pushed for a hearing, that there might have been evidence developed?
I didn't see it that way. I don't see it that way. I think at this point, that's a direct appeal issue. Mm-hmm. It's been preserved. It's properly framed. The Commonwealth has brought forward no additional evidence to suggest that circumstances have changed. They certainly have that opportunity. I mean, the case is on appeal. If they've got now exculpatory evidence or something that says, look, that witness we're protecting.
You've got a case where it's similar to this, that the failure to do this or to do it in these circumstances is reversible error?
Where the failure to hold a hearing is reversible error? SA is a case, I believe. SA, the Second Circuit case. Failure to disclose the informant's identity was error in the absence of an in-camera hearing. In fact, the court deemed them harmless, the errors harmless in that instance, but said that it was indeed error in the absence of an in-camera hearing. It's that Second Circuit case from 1988.
Okay, so that's your best case on this point.
Well, I think Roviero is this case as well. I think even Your Honor's Kelsey case.
I'm not finding, which case is this?
It's United States versus Saw.
Got it. All right, yeah, got it.
Yes, sorry.
Sorry. Go ahead.
But the cases Roviero, Kelsey, I mean, even the Massachusetts cases that follow Roviero establish that materiality is a low threshold, that it can be established on the face of the material itself. I do not believe Rule 30 was the vehicle to revisit this issue. I'm not aware of any precedent that would suggest that it is. I don't see how it would be. It appears that counsel properly brought the motion. I don't see anything that he failed to do other than to tell the judge, your job is to hold an in-camera hearing. He was acquiescent. I think that's very much the way he played the entire trial. He just went along and reacted to things. There are powerfully few motions that were ever filed, no motion to suppress, no proffered jury instructions, nothing like that. I tried, of course, to focus on the most salient mistakes and to frame things as I thought they were most reasonably to be framed in light of the fact that a motion had been brought, the motion had been heard and decided. I did not see that as a failure to press the point. Then the joint, assuming that the privilege even applies here, and I do not believe that the Commonwealth demonstrated that the privilege applies. This is a person willing to testify, appears to be a source, not a CI.
Willing to testify, well, that's not what seemed to come out through the telephone conversations that the prosecutor had with the federal prosecutor.
The fact that he's willing to testify.
That it was not willing to testify now.
Well, it's in the report that he's willing to testify.
That's the only place it is, because after that, that seems to diminish.
But we have no other evidence.
Well, you don't regard the report by the prosecutor of his conversation with the federal prosecutor as being pertinent information for the judge?
Pertinent information insufficient.
Well,
not enough.
But that it was confidential, a confidential source, confidential informant. That's what the judge took it as he was being told, and that that they weren't going to tell him anything more about the investigation.
It's all rather precatory, Justice Link. It's all sort of, well, he'd rather not do that. He'd rather not disclose. We don't even have it from.
Rather not or won't.
Again, I think proffers by counsel are, interesting, but insufficient. And I don't think you have a.
This is error by the judge, you're saying. This is error by the judge.
The judge should not have, exactly, the judge should not have denied the Roviero motion on the basis of the record before him. That is the argument. That it was sufficiently framed by the presentation of the report. The report on its face establishes relevance and materiality to the defense, both in terms of other culprit evidence and in terms of a potential Bowdoin challenge. This court and the Superior Court was not in a position to decide that this was attenuated or the person was not going to, because the court didn't have enough information to say that. And I submit that had the federal government really prevented this, there would have been a proper document from someone who has authority, not the line AUSA, but some supervisor, maybe even the U.S. attorney, saying this is not going to be turned over. And that was not done. And I think that Judge Whitehead was just of the view, I've heard enough, and let's start impaneling the jury. And that was that. I think that is insufficient. And I think it implicates state due process and also federal due process. I would like to say
Before you leave that,
okay.
Tell me precisely what you say the judge should have done.
The judge should have invited the prosecution to submit evidence, and the evidence should have more clearly established that this was, in fact, a privileged communication, a CI and not a cooperating source who was in a position to testify. In addition to that, the judge should have had an in-camera hearing as to who the source was and whether the source had information that was too remote to be useful or potentially useful. And third, the judge should have required the federal government to interpose, to insist that the information would not be provided, would have heard the government on its, there would have been some sort of presentation about the government's substantial needs. That should have been weighed. And then, assuming it goes the way I believe it goes, which is this is not remote, this is clearly relevant material to the defense, and there is really very little beyond a desire to protect, no real interest in protecting this witness, then you put it to the government, to the prosecution, the Commonwealth, and you say, you have to disclose it, or you have to dismiss.
Disclose what?
You have to disclose the witness's identity.
Okay.
You have to disclose the witness's identity. You have to allow the defense to interview the witness. And then that would, and if the Commonwealth said, Your Honor, respectfully, we are not going to do that, the federal government is not going to, we choose to dismiss, that's what they do. That's what Roviero says, and that's what...
Well, it's not for the federal government to choose to dismiss.
No, the Commonwealth would be put. No, that question would be put to the Commonwealth. Exactly, it's not the federal government.
If the Commonwealth could not get the federal government to cooperate in disclosing the information, you're saying that the result is that the Commonwealth has to dismiss the case?
Unless there is some other remedy that the Commonwealth can come up with. I'm not saying that it's automatic. I think that that is generally what's done. But if the defendant's due process interests can somehow be accommodated satisfactorily so that those due process concerns are met, then something may be short. For example, not explored here is, how long is this confidentiality required? Maybe, for example, a continuance in the trial would have been appropriate. I mean, there could have been other remedies depending on, what the government's showing was. But here there was no showing, and therefore there was, no basis to fashion a remedy that would meet the needs of the defense. And if I may, if there are no further questions on the Roviero issue, then I would like to go to this issue about the failure to argue premeditation. And I think it was given very short shrift by Judge Whitehead, and I think it's also been given very short shrift by the Commonwealth. I think it's a very important issue. I strongly believe that this is hardly an inconsistent theory of defense, as the evidence came in, and there really was no plausible pointing to even who in the video was the shooter prior to the shooting. You could see really nothing. There is no one who testifies who says anything about my client being there, even in Soriano's. Nobody places him in Soriano's. How do you ignore the premeditation problem? There really is no evidence. So I looked carefully.
Wait a minute, there's no evidence that he's the shooter as opposed to that he didn't mean to
I'm sorry, Justice.
I'm sorry, I'm not understanding the relationship between, you said that there was no one to put him at the scene as the shooter.
So you have no, I say, the way I believe defense counsel should have been alert to see that there was no evidence as to the behavior of the shooter, the mental state of the shooter, whoever the shooter was, prior to the shooting. No facts about where the shooter was, what had happened, nothing about that would lend itself to a reasonable inference that the shooter had contemplated and decided in advance to kill.
So as I read your brief, you're saying that it was ineffective for counsel not to argue, my client did not do it, and whoever was the shooter, there's no evidence of premeditation.
Correct. Or insufficient, I mean, or that the jury shouldn't have found premeditation.
Okay, but I mean, but isn't
Argue
the
against it.
jury going to hear that to mean essentially, my client didn't do it, but if he did it, he didn't mean to?
No, I don't believe so.
You think
I
you can
think
be
those are
that
separate
artful to
elements.
so as, I mean, but aren't there attorneys, I mean, there are capable attorneys who would say that essentially is going to be undercutting your best argument, which was that he did not do it.
I don't believe it undercuts. This is an 18-year-old defendant, and this is a chance to save his life, and it's a very good chance. It's a chance to keep him out of prison for the rest of his life. You don't give up the second degree when there's almost no evidence of premeditation. I would refer the court, if I may, if you'll indulge me, where it is that the Commonwealth says was ample evidence of the lurking in the shadows. He came out of the shadows. They cite transcript volume 3, page 61, for the proposition that the defendant was lurking in the shadows was supported. This is that testimony. Sheffrey Johnson says as she's standing outside, she of course thinks she's inferred that the person in the gray sweatsuit is the shooter, but she doesn't see the shooting. She says she saw a shadow pass her. She didn't see somebody come from the shadows. She said she saw a shadow pass her. She didn't focus on who it was. The other thing they cite is Exhibit 13, the tape. Does not show somebody coming from shadows. There is no evidence. I say, Your Honor, that even if this panel does not believe that this constitutes ineffective assistance, contrary to my argument, it is a basis for 278-33E review. This is really a case where if it was sufficient, it was very, very thin. And a fairer reading of the evidence is that this 18-year-old, assuming it is my client, and I do not, but for the purposes of this argument, that he reacted immediately to the let's go shoot some fair ones and dap and whatever the language is. And it was immediate. That's 2, or manslaughter. It is not murder 1. So I have no more time. I rest on my brief with respect to the hearsay and to the ID, and I think those are well fleshed out. If there are no further questions, thank you.
All right, thank you.
Thank you, counsel. Good morning. May it please the court, David O'Sullivan for the Commonwealth. I'll follow my sister in terms of the order of the argument and first address the issue of the Roviero issue involving the federal government's refusal to disclose a confidential informant who offered, as I think Justice Link aptly characterized, very attenuated information on who might be the killer in this case. The information was that this informant, working with federal officials, knew that had heard someone on the street, had heard someone say the word on the streets of Lynn was that Brandon Payne had killed the victim and that and after passed the gun to the defendant. The Commonwealth would of course agree that this is about the right topic. It's about who killed the defendant, but no less in Sinelli and in Day, where at issue were an anonymous Tibbs file concerning who killed the victims in that case.
But we don't know that this was anonymous, right? I mean, we don't really know anything about who it was who was saying this, other than that we don't know his name, but presumably the Lynn police officers do, and presumably the federal prosecutor involved did.
That's correct, Your
So
Honor.
it's not anonymous.
Well, it's not anonymous as to them. No, that's right. But they are, as the prosecutor relayed, as a conduit of information from the U.S. Attorney's Office, they were asserting the informant's privilege as to that.
Don't you think that was sort of a less than optimal way to do this?
It's not a way.
To do this, you make a phone call and then you tell me the contents of the phone call, and you can't explore what the nature of the investigation is. You don't even know the nature of the relationship between the Lynn police and the feds. You don't know if it's a joint investigation. You don't know anything about this.
Well,
you just sort of take whatever is being given you.
Well, with respect to the procedure that went down, initially the judge expressed a desire to have a hearing on the matter, and of course the Commonwealth did not object to that, at no point objected to having a hearing on the matter. And then the defense counsel, after the judge said, well, I'll accept what they say on the phone, did not object to that procedure either. I would agree it's optimal to have them come in and formally claim the privilege.
So the judge can really ask about all of these things and satisfy himself whether or not the federal government is really sort of in charge, acting as Bolivia, which is why I think he characterized the relationship between his court and the sovereign. It's as if it was, the government of Bolivia saying, I'm not going to turn over the information. I don't know exactly where he got that from.
Well, the report makes clear that the two Lynn officers were working in connection with federal authorities in a separate investigation in which this informant who was providing information in that case also provided information about this case.
But I got to tell you, I don't understand how if, there's a joint investigation, for example, and we don't even know what the nature of this cooperation was. I don't know that means that the federal government could put the kibosh on being able to disclose anything in a state court. If also Lynn employees were involved in this and maybe they were co-equal. I don't know how to judge any of this.
Well, there's an important point. It's addressed at footnote 21 of the Commonwealth's brief. There is no evidence or suggestion on the record that there was a joint investigation in the investigation of this crime.
Well, the trouble is there's just no evidence as to lots of stuff.
Well, but there was certainly no evidence. I mean, there was not a single federal witness in this case. There was not a single federal report that was used in the case. I would contrast it with a case like Lycus, where they were jointly investigating a case that was ultimately...
this case as opposed to whatever it was that the informant, that case.
Correct. Yeah, there's no evidence that federal and state officials were jointly investigating this case. They weren't. Yes, they absolutely weren't. This was not. There was no federal involvement in the investigation of this case. The Lynn officers were working in connection with a totally separate investigation with federal officials. Were paid by the federal government.
Well, we don't know that either for sure. We only know what was passed on by the prosecutor.
Well, we know that according to the report and according to what was passed on to the prosecutor,
We have that in the report? The report says that?
The report makes clear that they're described as federal agents as special agents in the report. And as the prosecutor related from the U.S. attorney, they are paid by the federal government and they are completely funded by them in connection with their efforts there.
Let's imagine you had that same set of facts, we'll even call them CI as opposed to a cooperating source. Instead of saying I heard words on the street, saying I saw the whole thing, and it wasn't Bonnett who did the shooting; it was Starks. I saw it. Yeah. Same set of facts?
Very, very different set of facts.
Okay,
Thank you, Your Honor.
So tell me what should have happened in my hypo, and tell me why it was okay to do it differently in view of these facts.
In that hypothetical, I think this court's Liebman decisions would control and would basically say this: ultimately, it doesn't matter who has that type of information, whether it's a separate sovereign or us. The unfairness of the defendant, given the nature of that information, which is relevant and helpful to the defense, essential to a fair determination of a cause, because it's a percipient witness testimony that supports the defense case. It's clearly exculpatory. It's clearly admissible. That is a very different situation from the attenuated information that we have here. And it wouldn't matter that a separate sovereign had that information, because as Liebman makes clear, if they have information that qualifies as material under our cases, then the Commonwealth must dismiss the case if the separate sovereign refuses to give it over. And that gets to the essential point here, that the key point is the nature of the information that the informant purported to have, which was information that was clearly not admissible under this court's cases. The defendant's argument depends on a hypothetical. It depends on the speculative possibility that this might lead to that evidence, that the report doesn't disclose that there was information in the hands of the informant that was itself exculpatory and material, but it might lead to that. Well, no less in Sinelli and Day, they could have, this court in those cases didn't call that information material on the theory that the defense counsel could have used it to obtain or to later develop such information. And I think it's telling that the defendant, in connection with his motion for new trial, didn't pursue this claim, given the indication from the U.S. Attorney's Office that their resistance to the disclosure of this informant would be time-limited, as the prosecutor relayed.
But you're shifting the burden to the defendant in a way that I'm not sure really works under the cases. You really have to defend the decision that the judge made at the time the judge made it.
There are two different burdens that are potentially applicable in this situation, Your Honor. The first is the burden to demonstrate that the informant privilege applies. This office didn't claim the informant privilege. We don't have access to the information. The second burden, and albeit a light one, is the defendant's.
So no claim as to the informant privilege, but that's a little bit different than what the judge seems to have found.
No, there's no claim from this office, Your Honor. It's a separate sovereign that's claiming that, and had we been claiming it, we would have carried that burden. What the defendant has to show, and this burden is admittedly a light one, is he has to show a substantial basis for claiming materiality in the information, and that's where the defendant's claim fails in this circumstance. But that burden is most assuredly on the defendant, not the Commonwealth, to disprove that. Now, in connection with his motion for new trial, given the time-limited nature of their apparent resistance, or given the fact that they said he was, quote, in a position to testify at some point down the road, 2 years later in the motion for new trial, the defendant does not seek this information. But instead, on appeal, now simply wants the court to reverse the conviction. This, of course, assumes what they're trying to prove, which is that release of this informant's information would lead to material exculpatory evidence that might have made a difference at the trial. It's telling that they didn't pursue that course, and even on appeal, they haven't asked for a remand for a hearing. What they've asked for is a new trial. Now, with respect to the issue of premeditation, this is, if there are no further questions on that issue, I'll move directly to the premeditation issue. This is a quintessential tactical decision of counsel, and of course, those decisions are afforded deference, particularly in a circumstance like this, where there was a well-thought-out and coherent defense theme throughout that accommodated in a skillful way the damning evidence that the Commonwealth had, particularly the DNA, the palm print on the murder weapon, the defendant's confession to Joseph Burns that he committed the crime. That confession included details about the crime that had not been previously released, particularly the fact that there was no magazine in the weapon, and particularly where the weapon was found. In the second conversation that the defendant had with Joseph Burns on Western Avenue, the defendant asked Joseph Burns, "Can we go look for the weapon?" And that was consistent with where the video, Exhibit 13, shows the shooter ran and where the weapon was found that night. It's a key point that the weapon was found. Police arrived within 48 seconds of the shooting, and one of the responding officers found the weapon just feet away from where the victim was shot. And the defendant's palm print and DNA on that weapon are particularly powerful evidence, particularly in that context.
What's the evidence of a relationship between the defendant and Payne?
There was evidence from the defendant's interview that Payne was, quote unquote, his boy, and that they had the same tattoo, and that that the Officer Withrow, had only seen that tattoo, had seen hundreds of tattoos, but had only seen that particular tattoo on 2 people. The tattoo was squad with an arrow pointing upward, squad up. And that was the information about their relationship at the time of trial.
Because it was Payne who was having the conflict with the victim.
That's correct, Your Honor. And the defense theory posited him as a possible suspect, and repeatedly throughout the trial pointed at him as a potential suspect. They pointed out that the DNA, the mixture of DNA in the backstrap of the weapon, Payne could not be excluded as a potential contributor. The statistical numbers were not very impressive in that regard, but still counsel made use of it. He made use of the fact that Payne had argued with the victim immediately before the death, and Payne, the defense called Detective Sergeant Nardone as a witness, who testified that immediately after the crime he had arrived, and by 1:20 Payne had left the scene. And also, the defense's last piece of evidence was to show a portion of the videotape interview of Sheffrey Johnson, in which Johnson was asked or told detectives that when I began to date Brandon Payne, I asked the victim whether it was okay, and he said it was fine because asked the victim and or Brandon Payne whether it was okay, and they affirmed that any dispute between them had been squashed. And then the opening began with, well, apparently it had not been squashed, essentially an argument to that effect, because they were arguing that night.
Was Payne in a relationship with Johnson throughout the time that she gave the statement afterwards and testified before the grand jury and testified at trial?
The record does not disclose that, and I'm unaware of that. It would be difficult to sort of verify that type of fact, but the record does not show.
Payne testify at trial?
Payne did not testify at trial, Your Honor.
That leads to the admission of the Payne hearsay statement that Black was the shooter.
Yes.
How was that not ineffective?
Well,
that's pretty powerful, relatively spontaneous evidence of who he thought was the shooter, and he's not testifying.
Right, and just to be clear, this is where the prosecutor on direct examination of Sheffrey Johnson asked, did he go anywhere, meaning Brandon Payne, immediately after? And the Johnson replied, a non-responsive answer, I just remember saying, who the fuck was that just shot my cousin? And I was like, your fucking boy just killed my cousin. Who the fuck was that? And he said, meaning Brandon Payne, Black, that was Black. As the judge found in his motion for new trial ruling, this reinforced the point that Johnson herself had not seen the shooting and that her knowledge of it came from a person who himself was a suspect, offered by the defense as a possible suspect for the murder. The other point, which is not adverted to in the judge's ruling, but I think is powerful, is that decisions to strike are also quintessentially tactical ones, because they could, an instruction to disregard can have the opposite effect, of course, and striking this testimony could serve only to emphasize it to the jury.
All right, so you're suggesting that supports the idea that what you just read about the testimony from Johnson supports that she didn't see anything that was actually helpful to the defense?
Or else she would not have had to.
Even though it just followed the testimony that she saw Black standing over the victim and put a gun in his waist?
Well, that testimony, that's percipient witness testimony.
Right.
It's not the hearsay identification.
I just don't see how you get from that to, oh, this reinforces the idea she didn't see anything.
Well, she wouldn't have had to ask Brandon Payne if she had herself seen the shooting.
Well, it could be read not as an ask. Could be read as, who was that did that?
That's true, but on cross-examination throughout, she admitted to having her back turned to the shooting itself, and she turned when she heard the pop, and literally the next second saw him tuck it in.
Okay.
Yeah. But throughout the defense, I think ably made the point in its cross-examination of Sheffrey Johnson that she had not seen the killing itself, and that enabled him to argue to the jury that the defendant was not on trial for what he may have done after. And that may be a quote. He's not on trial for possibly having disposed of the weapon after he was shot. Brandon Payne was the one who argued with the victim immediately before, and this, of course, accounted for the DNA and the palm print evidence in a way which was difficult evidence for anyone to address.
But didn't Johnson also testify that she had pain by the arm and was pulling him away?
Right.
While and then heard the pop? So, I mean, her testimony seems to be fairly crucial.
Her testimony is right that she had pulled him away. When they had expressed a desire to shoot the ones around the corner, she had swung him around so that she was no longer facing the victim.
So he didn't really need to get more information from this statement that she made as to whether or not she had seen the shooting, because she herself was testifying that she hadn't seen the shooting.
Yeah, well...
So it's such a subtle point that you think
well,
that this somehow advantages the defendant. It's hard to really understand how it does.
Well, it's a decision not to move to strike that. That's at issue here. And of course, the defendant testified to a tactical motive for failing to do that. So it's that level of deference that we have to give in those sorts of situations. As the judge said, other counsel might have acted differently, but you can't fault him for doing it in this circumstance, particularly for that additional reason that I mentioned in the brief, but it was not mentioned in his ruling, that striking can lead to emphasis. It was clear that Sheffrey Johnson was an emotional and volatile witness. She had an outburst in the course of watching the videotape in which she swore and said, you know, he killed my effing cousin. And it was clear that her testimony was vociferous and accusatory in a way that the judge said undermined her credibility. And I would point the court to counsel's cross-examination of her making his essential points in the case. So if there are no further questions, I would rely on my brief on the other issues.
Okay, thank you.
Thank you.